Welcome to the PinkpillRx podcast, hosted by Katie and Jay Fillmore, where we navigate complex and thought-provoking topics surrounding women with a focus on education. For shorter form content, follow us on TikTok, Instagram, or YouTube at Caters88 or PinkpillRx.
That's Kators 88.
If you enjoy this podcast, please give us a follow and maybe a nice review. So before we begin, I want to remind our listeners that with the potential TikTok ban on the horizon, you can always find us on YouTube and Instagram. And we're committed to keeping our community connected regardless of what happens with TikTok. So make sure to follow us on these platforms to stay up to date with all of our content. And hey, if you love what we do and want to support our mission, consider joining us on our Patreon for $1 a month. And your contribution, it helps us continue bringing you this content. Also, if you have a story you'd like to share with our listeners and followers, please email us at pinkpillrx@gmail.com. All stories are shared anonymously unless specifically stated that you want your name included. As a reminder, we're your hosts, Katie and Jay Fillmore, and we're thrilled to have you join us for another eye-opening episode. Today, we are really excited to have a guest with us. She's our first remote guest, so please be patient with us if there's technical issues or things like that. Our guest today is Tashina Gorgone. She's an owner at Maddox and Girock PC in Falls Church, Virginia. Tashina graduated from the University of Mary Washington with a Bachelor of Arts and obtained her law degree from George Mason University School of Law with a concentration in litigation. Her practice focuses on the areas of family law and appellate litigation. Tashina handles all areas of family law from custody to child support to property distribution and has particular experience and interest in complex custody cases, having handled cases involving international custodial issues, allegations of domestic violence, substance abuse, and sexual abuse. Tashina serves on various boards of the Virginia Trial Lawyers Association, including the Family Law Section and the Women's Caucus, and the Northern Virginia Women's Attorney Association, and she is actively involved in the Fairfax Bar Association. Tashina is a recognized super lawyer. She is also acknowledged annually in Best Lawyers in America and Virginia Business Legal Elite in the practice area of family law. Tashina is a Northern Virginia native and currently resides in Fairfax with her husband, Alex, and their three dogs, Copper, Penny, and Tuppence. In her spare time, Tashina can be found traveling or performing with various local community theater groups. None of what Tashina shares today is legal advice. If you have legal questions or concerns, please speak to legal counsel. Tashina, welcome, and thank you so much for being here.
Thank you both for having me.
Yes, we are so excited. What started this was there was a video. Well, what started with me really wanting to get a family lawyer on here was there was a video that went viral not too long ago talking about how when you are in a custody battle, if you claim domestic violence or domestic abuse, that women are shown to often lose in those situations or lose the custody that they were going for. This isn't necessarily like losing total custody per se, but let's say they were going for more time or something like that, and then it doesn't pan out that way because they bring up domestic violence is what at least some statistics say. So I didn't realize that. I had no idea that that was even a thing. And it got me really interested in gender bias in the courtroom and what that kind of looks like. So I am so happy that you're here because I would love to discuss that and discuss the bias that maybe you've seen, if you've actually seen when somebody has brought up domestic violence, if that has made an impact or not. So yeah, I would love to discuss that, and I would love to just jump right in, if that's okay with you.
Sure. Yeah. I want to further kind of caveat and clarify with, of course, the experiences that I'm going to share are my own. They're not necessarily reflective of anybody else in my firm or any other attorney in Northern Virginia or the Virginia area. So I am speaking for myself from my own both anecdotal experience and just the experience that I have when I participate in continuing legal education seminars or when I do meetings with mental health professionals when we're talking about the roles and dynamics of gender in child custody situations. So I know it's an additional kind of caveat that I have to do the lawyer thing, but that's where we are. But I will cut to the chase to say, yes, I do see exactly what you are describing in my cases at times. it's always a little bit more nuanced and a little bit more complex than just they claim or share their experience, a woman does, of domestic violence and losing custody as a result of it. But that is kind of a layer undercurrenting what we might see in a courtroom setting. So if it's all right with you, I could even kind of take a step back and talk about the framework in which custody disputes might find themselves in court in the first place, and how then allegations of domestic violence interact with that.
Yeah, I would love that.
That'd be great.
So oftentimes what we're seeing when a client comes into our office and we're screening for domestic violence, which I can say I try to do in almost any case that comes into my office, but with particular attention to the female clients, potential clients who are coming into my office. I'm doing a domestic violence screening to kind of get an idea of what the dynamics were in the marriage up until the point that they either already separated, or if a client is considering separation, might be influencing that decision. Right. So screening for domestic violence is important because a lot of times, I'm not going to say a lot of times, there are times where clients might not even necessarily know that they are in that kind of a relationship in the first place. And that can be difficult because you're both trying to screen them and educate them, and simultaneously educate them on how that dynamic might influence their future custody disputes. When screening for domestic violence, one of the things that we will do is we ask open-ended questions, right? Well, tell me about how you and your spouse, traditionally a husband, have resolved disputes when you've disagreed on something. You know, how do those conversations occur? You wait and you hear from them, and I hear enough times that, you know, it's a statistically significant figure. Concerns about dynamics where maybe the husband is very unkind in how they speak to their wife about dispute resolution. Or I see samples of emails where it's more than just disagreement, it's name calling. It's you know, sometimes really heinous and vile stuff. And they're like, well, that's just how they've been, or that's who they are. And so it's taking that step back and talking about how that interplays with the kind of attitude and the overlying respect that they might have for the woman in the relationship. Because if they're willing to do it in a conversation where they're putting it in writing, they're putting it in email, they know that this is going to be seen, you know, what is that saying behind about what's actually happening even behind closed doors? And that can be really difficult. What happens in these situations, though, is that we immediately start, or rather I immediately start trying to talk to my potential client or my client about, let's be very specific in how we talk about these things. Because where I see gender bias come into the courtroom, or where I see allegations of domestic violence kind of going wrong, I will say, in the courtroom, is when a client is conclusory only. If a woman comes into court and says, my husband shouldn't have custody of the children because he's abusive, that doesn't tell us very much. That doesn't tell a judge very much. And that can be difficult if that's the only thing that this person is able, either because of the rules of evidence, or because they aren't a good public speaker, or because they're very nervous. If that's the only thing that they can communicate, that doesn't give a judge something to hang on to in terms of trying to make a decision about what is in the best interests of their children, which is the mandate that judges in pretty much any state, definitely in Virginia, have when analyzing the evidence. So I often will tell a client, I need you to not tell me, I need you to show me. And that's advice that I was given back in a creative writing class once upon a time many years ago, was examples are going to be the way to paint the picture of what you're trying to communicate. Don't be conclusory. Don't say he was abusive to me. Tell me what happened when you two would argue. Tell me what would happen when you would try to remove the children from the room so that they wouldn't participate or see the argument. Tell me what would happen when he would block the doorway so that you couldn't get out of the room. Tell me what are the words that he was using that you felt were abusive. If you just say he talks to me in a bad way and he's abusive, you're not allowing me to then turn that into an argument to present to a judge about what the evidence is of that abuse. And that can be a real nail for a lot of people, especially women in domestic violence situations who are going into court unrepresented or trying to represent themselves because they just don't know what it is that they need to be communicating to demonstrate the, and I hate to use this word, but right, the legitimacy of what they're claiming. The courtroom is a very sterile environment. It is very sanitized. And by that, I mean, these judges don't know anything about your life other than what they get in the 1 hour, 1 day, 2 days that they have of you in their courtroom. You're bound by the rules of evidence. And that can make it really, really difficult to put on a compelling case. And if a judge thinks that you've come in and cried wolf, essentially, at the end of the day, they are wondering on the other side what is going on about your lack of desire for your husband to have time or have custody with these children. And that's how they can end up inadvertently, I'm going to say perceived to be punished, feel punished for what they've done when they feel that they've just been speaking a truth because they aren't sure how to go about communicating that truth.
Wow, that's super insightful.
Yeah, very practical, very
Yeah.
applicable.
So how does that turn into like a he said, she said kind of thing though? Or I mean, do they really need to show you have physical evidence?
And they're in the rub, right? So it's yes with an asterisk. Calling it he said, she said is probably the simplest, most accurate way to describe it, because at the end of the day, what a judge has is evidence. Evidence is testimony. Evidence can be documents. Evidence can be photographs. Evidence can be, recordings, but it's subject to limitations. So by that, I mean, for example, the thing that most impacts, in my opinion, the ability of a woman in a domestic violence situation from being able to get really credible, reliable evidence of her experience before a judge is that it's so often happening in isolation. So there's nobody to corroborate what she's experiencing. So then a judge says, I want to believe you. I didn't have your credibility impeached by the opposing counsel on cross-examination, but I also have no reason to disbelieve him, and his credibility wasn't impeached on cross-examination. And so now I'm here holding both of your opinions validly in equipoise. And it's not like a beyond a reasonable doubt standard, right? But it's a preponderance of the evidence standard where you need that 50% plus 0.01 to get to that level. And because so much domestic violence happens in isolation, it's very difficult. There's not often going to be a witness who saw it. Maybe the children saw it, but you can't talk about what the children said in court. That's hearsay. Hearsay being a statement that somebody made out of the courtroom that you, the person who is trying to repeat it, is offering for the truth of what they saw, right? So having a teacher on the stand to say, little Brian came into my classroom upset yesterday saying he saw daddy hit mommy, that's not admissible evidence. The way to get around that, I'm going to put that in quotes, is for the child to come in and testify to what they saw. And that's almost never an option. And I don't mean that legally. You're allowed to call whoever you want as a witness. A judge has to decide whether the child is of an appropriate age and, mental capacity to be able to testify, to understand taking an oath to tell the truth. But what mother wants to put their child on the stand to have them repeat what they already saw as a horrifying experience, just so that then on cross-examination, an attorney can say, but don't you still love your daddy? Don't you still want to spend time with your daddy? And so then it becomes its own form of abuse, right? To know that the only way you're going to get your evidence before a judge is to subject your child to that. And that you're going to be blamed for subjecting your child to that, because most judges, when they speak to us, will say calling your child is the nuclear option. And so then you get penalized for bringing your child to court in the first place, because you're the one that subjected them to the trauma. Not the person who, by the way, abused you in the first place and created the world where you have to bring your child in to testify. And so it's a complete no-win situation for women experiencing domestic violence, especially if they weren't contemporaneously reporting it, documenting it, and doing those things, which, by the way, comes with its own host of complications, right? Well, if you
Right.
reported it, why did you stay? If you didn't report it, did it really happen? If you reported it, but you reported it in a written affidavit and you didn't get every factual detail completely correct about what you said, well, then you're going to be cross-examined about, well, you said that your child was standing 10 feet away. They actually were 20 feet away. And if you can't be believed about that, what can you be believed about?
He's losing his mind over here.
Yeah, it's lose-lose, and it seems very antagonistic. Like, man, any little discrepancy or anything you do is going to be judged, and it's going to be twisted into a different point of view. And
it's something we grapple with every day, right? There's an idea, there's jokes aplenty, right, about lawyers being in courtrooms trying to make everybody out to be the bad guy. We don't love it. We don't relish it, right? And so it's one of the reasons why I take these experiences and what I've seen happen, and I use it to try to keep people out of court in the first place. I often tell my clients, right? Like, I am not afraid of court. I will go to court. I will litigate your case, but I know what gets weighed. I know what the risks are. I know when my client is unfortunately not going to do well on the stand for what might be very legitimate reasons. But I take that data and I say, okay, here's what we're going to try and do with that. We're going to try to work something else out of court, because at least then there's certainty. There's stability in that you had more control over the outcome. And I'm not going to pretend like those are always good outcomes, right? A mother might end up giving more custody, physical time to a dad than she would like to, because it's still hedging her bets of the risk of what might happen if her claims about domestic violence are not legit, like found to be legitimate in a courtroom setting. I will say that brings me to the statistics that you were citing and going through on one of your earlier podcasts that sort of caught my intrigue in the first place, which was the high percentage of men in litigated all the way to completion custody cases that end up with custody of their children. And that was like a really surprisingly high statistic. I want to contextualize it a little bit more so that it doesn't feel maybe quite so dire for women. The majority of the cases that come through our office or that come through, my representation are going to settle. We have noticed maybe an increase in litigation in the post-COVID world. People seem generally a little more disagreeable in the post-COVID world than they were before 2020, but more times than not, a case is going to settle. And so when I see a father who is not settling his case, generally one of two things is happening. No absolutes, but generally one of two things is happening. Either there is legitimately some concern. The mother maybe is experiencing some really significant substance misuse issues, or she's just not in a place right now that, and she's not willing to recognize it or work on it, or she's like, there's legitimately something there. But I will find that more often what it is, if there can't be a settlement, is the man is a coercive control type personality. And so that's one of the ways that I try to get around, and again, get around isn't the right phrase, but it's the best that I have to work with, these pushbacks on domestic violence allegations. In my experience, where there is physical domestic violence, there are other forms of violence, and there are forms of coercive control, whether it's financial, whether it's emotional, whether it's verbal. I have found a lot more success in using coercive control dynamics to highlight bad parenting on the father's side and bad co-parenting on the father's side than I have allegations of domestic violence in the physical realm.
Oh, interesting. That's surprising to me. That's really interesting.
Well, I will say that it goes back to something I was talking about a little bit earlier with, the email example. And if you're willing to put it in an email and you're willing to talk like that in an email, what does that mean about what's going on behind closed doors? Coercive control type personalities, it's right there in the name. They like to have control. They are the personality that is going to say, You said that the children need their tonsils removed because you took them to the doctor. And even though you've been the one that's taken them to the doctor for, the last 10 years of their life, I suddenly am now in a custody dispute. I'm going to go to the doctor with you. I'm going to question the doctor's advice. I'm going to ask for a second opinion on that tonsil removal. I'm going to say that I can't agree to that until I have my questions answered. And because prior to a full custody determination, our parents in our law have joint legal custody. And even after a custody determination, most people primarily end up with joint legal custody, which is separate from physical custody. Legal custody being the ability to make decisions about the health, education, general welfare of your children, right? Most judges are of the opinion that at a baseline, people who had children are reasonably able to participate in the decision-making about your children. And so in a joint legal custody context, there's a general understanding that you have to have agreement. And when somebody is becoming obstructionist because they want to exercise control, well, then I start to use that obstructionism as evidence of what they must be like behind closed doors, right? Judge, here's the email where dad is saying he's not going to agree to the tonsil surgery until he gets a second opinion. Great. I told my client to play along, go get that second opinion. Here's the medical records, with an appropriate custodian of records affidavit or with the doctor testifying to get around my hearsay objections that said second opinion, kid still needs tonsils. Dad said yes, finally, except then he disagreed to the date of the surgery. He disagreed to the doctor performing the surgery. And those kinds of people, they can't help themselves, right? Like they're abusers, they want control, they're going to needle it, and they're going to always do it through the guise of, well, I'm just trying to make sure that we're making decisions that are best for our children. Why don't you also want to be making decisions that are best? It's exhausting. I acknowledge it's exhausting. And it's exhausting to have to build that kind of a case. But every email like that and every micro decision like that expands into a bigger decision like that is the coercive control person digging their hole a little bit more to show what their real priorities are. And I find that in the long run, that's a lot more successful because it's something tangible, visible in the emails and in the records that a judge can see. Can compare it to their testimony on the stand, because if you ask the right cross-examination questions, you really try to pin them down on something. They don't want you, the lawyer, cross-examining them to win. So they try to squirm out, answer the question you didn't ask, answer the question they want you to ask. And that starts to show, it breaks the facade. That gives the judge something then to say, I saw that and I didn't really find that person credible, or I saw those emails and I think that it's just protracting the disagreements and it's not good co-parenting. And so in the cases where I have been able to go back and successfully get a mother more custody, whether physical or legal, it's been when I've been able to show the coercive control that often accompanies the domestic violence aspect of the relationship.
And that is really brilliant. Would you say that that's more effective than having things like a restraining order or something like that?
Oh, that's a great question.
Like in your personal experience, not like as like, again, this is not legal advice or anything
No,
like that.
no.
I'm just so curious.
I think it's a great question because it's kind of a two-part answer. In an initial custody determination, so whether you're a married couple who's coming in, separating, getting divorced, and this is going to be the first time you're making a formal custody decision, or whether you are an unmarried couple who has children together, but now you've broken up and you're no longer together and you need custody determined for your child. If you first come into my office and you say, he's been abusive to me in the past, I'm going to ask you the questions of how long ago was the most recent physical abuse? Was it to the children? What were the circumstances? And unless I hear really compelling answers that something happened imminently or just recently, I'm going to tell you not to get a protective order right, like at that first instance. Because what happens, unfortunately, is that I'm going to say, man, husband, father, whomever in that situation is going to hire the lawyer who is going to immediately use your desire to get a protective order to weaponize against you, to say you're trying to get a leg up in custody. Because a protective order is a faster order, it's more immediate, it has the power to make temporary custody decisions. So there, are these allegations then on the other side that if you go and get a protective order and it covers your children and you've now severed the communication and the contact between a dad and their child, when you really should have been pursuing a custody case to get longer term decisions, and you're kind of just trying to use this to get an advantage, that can end up backfiring. I've seen it backfire. I've seen it backfire because of allegations in an affidavit for a protective order that didn't match a video recording of what might have happened, right? And that's not because the mom is a liar. It's because she was under extreme emotional distress and didn't remember that she was wearing red instead of blue that day, or that, maybe she did lash out and grab the phone and she just didn't remember in that moment, right? It's not often that it's people being like diabolical. Now, I will caveat that to say that there are unfortunately circumstances, right, that where the bad apple ruins it for the bunch, and somebody does use it as a leverage or weaponizes it, and the judge remembers that one time that it happened, and then that's the bias they bring to all of their future cases. And so we have to navigate that. And so I won't often advise a protective order at the start of the separation. If something goes terribly wrong during the course of negotiations or while we're waiting for trial, say there's a custody exchange happening of the children, and my client, the mom, has been trying to do everything right, trying to get contact, and dad attacks her in the parking lot at a custody exchange, shoves her into the street. That is an example that I had once. Like, I did have that client go and get a protective order then during the pendency of the proceedings because an act of abuse happened during the negotiations and during the kind of waiting period. And the way that I was able to refute evidence of getting a leg up, or allegations rather of getting a leg up, were this man did this thing, there were witnesses, and if he was behaving like that during the course of this litigation, when he also has a microscope on him, then we need to be worried about that escalating, that behavior escalating. And so I take all of this into consideration when I'm making a recommendation. And I'm not saying that like I'm happy that these are my recommendations, right? Like that, I want to be very clear. This is all just navigating a system that is not yet adequately prepared to accept the realities of a victim of domestic violence life. But we navigate it the best we can.
Regarding an order of protection, from your experience, if a woman has an order of protection prior to seeking legal counsel for a divorce or for custody, does that fare the same way as if you have your initial meeting and then do it? Or if something seems to be more pressing and they have this order of protection and then later go for legal counsel, does that fare any differently?
I would say that in terms of how it might play out in court, I think it could fare differently because, one, judges can see the whole file and they can see what the timeline was, right? When was the application for a protective order made? Was it granted? If it was granted, how long was it granted for? At what point did these divorce proceedings begin or this custody case get filed? And so there's always an interplay, right? And that's where good advocacy comes into play as well, right? If I have a client who comes in and already has a protective order against their spouse, I obviously want to know everything that went into what happened to get that protective order. I'm not going to encourage them to do anything that could be perceived as weaponizing the protective order. But I'm going to want them to comply with the protective order, and I'm not going to tell them asterisk, except in certain circumstances where it might be appropriate for a variety of other reasons. But my general rule would not be that I would want them to dissolve the protective order in favor of some other arrangement. So I think that there's a difference insofar as if it's already been adjudicated, because an order of protection does also ultimately go in front of a judge who has heard that evidence. And so now there's a finding of family abuse because a judge has ruled it as such. That's very, like, I consider that different because now it's not a he said, she said, now it's a judge said.
Yeah, I had a couple of follow-up questions just from things from earlier. So to avoid the he said, she said type of dynamic, let's say, because they make all types of like baby cameras and whatnot. Like we've had some because our toddler gets into everything. So you have different ones in the house. They record to a cloud. So you have these videos. Are those something would those be admissible evidence? Or is it kind of depend, or does it depend on your state? Or I don't know if that's a thing or
I
not.
would never be a good lawyer if I didn't start with, it depends. So it does depend, and it depends on a couple of things. One, it depends on what the video is capturing. So we have to be careful because there's a dynamic between what happens in a happy functional relationship where you guys are all on the same page about your cameras, and in a tense separation situation where maybe husband and wife are living on different floors of the house and they never historically had a nanny camera, but now suddenly one is being put in, and why. It also depends whether or not it's recording audio. Our federal laws have electronic interception acts as a part of them, right? That say you're not allowed to intercept certain types of communication, right? So if it's a nanny cam recording somebody on the phone saying something problematic or abusive, or on a FaceTime, right? Now there's layers that we have to You also have to be careful about, are you recording something that would be in an area with a reasonable expectation of privacy, right? Is your camera trying to record something in the bathroom versus something in the backyard? All of that, though, is just stuff that we as the lawyers are assessing on the pre-trial side. And we're looking at, where did this come from? What was its purpose? Why did you have it? Can we get it from somewhere else? So, you know, a subpoena for ring cam footage that your neighbor's ring cam across the street caught, something like that. So there are times, yes, where video recordings can come into evidence. I tend to prefer the ones that are a little bit more automatic, like a ring cam or a nanny cam, because, you know, if it's motion detected, then it eliminates some of the question of like, well, why did you start recording right then? Right? If it's a husband or a wife coming in with, here's my recording that shows that I didn't abuse my wife during this argument, and it's a camera that, you know, is jostling around and you can't really see anything because they just put record on their phone and then they were holding it and waving it around. Like, you can't really see what's actually happening. You can hear. Hearing isn't always going to elucidate the picture. And we're kind of back in that he said, she said. I will also say, though, judges generally advise us that they don't love recordings as evidence, because, especially in the ones that are controlled by somebody, because we have no concept of what was happening right before the recording started. The person who knows they're recording has a little bit of like a home team advantage because they know that what they're saying is being recorded. And so where I actually see it backfire a lot of times are those coercive control type personalities that will record to be like, look at how unreasonable she was being, but you just hear them needling their wives, right? Or pushing them, you know, like, well, why are you doing that? Why are you saying this? And like, you hear her snap eventually, right? But you've had this lead up of, well, actually, sir, I think you kind of just undermined your point there. I will say one of the worst cases, what worst isn't the nice word. We'll scratch that. One of the hardest cases I had was a case that involved allegations of domestic violence, that the husband had been abusive to my client and to the children. And he recorded, and he recorded constantly. And he recorded because, one, he thought he was capturing how she and the children spoke to him and that they were being abusive to him. Two, he thought that their living conditions were such that, because she was supposed to be running the house, her failure to do so adequately would be great evidence about her, you know. Yeah, that's the face I make too. You know, and so he played recording after recording after recording, including a recording where my client had a full-on mental breakdown. She was cursing at him. She was screaming at him. She did come at, like, it was not a good recording. But the judge, in making his ruling, where, by the way, my client did get full sole physical and legal custody ultimately.
Wow.
He said, he was like, the thing with these recordings, sir, was that you thought this was helping your case, but all we saw was your wife having a very legitimate emotional breakdown, and instead of helping her, you recorded. Right?
I like that. I like that judge. I've heard some bad judge stories, but I like that judge.
Well, but I will say that that was the same case that got started before I was involved, with allegations of my client getting a protective order inappropriately as a leg up for custody. And the issue that became crystal clear in that case was that she could not corroborate the acts of physical abuse that she had endured at his hand, But things like him reporting goes right into that coercive control argument that I was talking about, that I was able to use his reportings against him to help persuade the judge that this was the bigger problem. And I don't say that to be flip and to say physical abuse is not a problem. Like, of course it is a problem. But that's a problem that we couldn't see, and so we can't solve other than to separate these people. We can see this, and we can see that he thought this was a good idea. And what does that say about his ability to accurately assess and meet the needs of his children? What does that say about his desire to maintain a close relationship with them? Because those are all other factors that the court has to consider in making a custody and visitation determination. And so where I can't necessarily prevail on incidents of family abuse as a factor, I'm going to take that behavior, the behavior of the person that is accused of engaging in acts of family abuse, and I'm going to highlight other areas and other factors where that behavior kind of evidences itself as a way to give the judge more than one basis upon which to rest a ruling.
We want to thank Tashina for joining us for part 1 of this series called Family Court, and we look forward to talking to her again next week for part 2. Please join us for part 2 next week.
I hope for those of you listening, something was intriguing or sparked a curiosity, or you felt affirmed or challenged. Stay educated. Take the pink pill. If you enjoyed this podcast, please give us a follow and maybe a nice review.